in Parliament should be sued in his personal capacity for executing official duties, and it is a finding therefore there is misjoinder of the fourth and fifth respondent in these petitions in their personal capacity. The second issue we identified is whether the respondents have disobeyed court orders on the use of omnibus bills and are therefore in contempt of court. We have noted from analysis that although the targeted amendments were conveyed in a single bill, the individual statutes were clearly flagged out and committed to the relevant departmental committees for consideration and collection of public views. The information was relayed to the public when they invited through newspaper adverts to present their views. We therefore find and hold that the use of an omnibus bill to effect the amendments did not impede public participation and there was therefore not unconstitutional. With regard to the question whether the respondents are in contempt of court, we find first that there was no order prohibiting Parliament from using omnibus bills, and secondly, that there is no constitutional or legal provision that prescribes the manner in which omnibus bills should be used in Parliament. And thirdly, we find that the first, second, fourth, and fifth respondents were accordingly not in contempt of court orders. We have set out in detail our reasoning in respect to these conclusions. The third issue was whether the legislative process leading up to the enactment of the Statute Law Miscellaneous Amendment Act was constitutional. We know that the petitioners have contended that the act should be declared unconstitutional because it did not contain a memorandum of objects and reasons as required by National Assembly Standing Order 117 and 122. It is also their case that the inclusion of amendments to the Public Finance Management Act in the impugned act demonstrates that the National Assembly debated and approved a bill different from the one that was subjected to public participation, which rendered the amendments void for failure to comply with Standing Order 114 of the National Assembly. We have found that the errors pointed out by the petitioners were generally minor infractions of the rules of the National Assembly and which do not render the impugned act unconstitutional. We have come to the conclusion that this court cannot supervise the day-to-day operations of Parliament. We have, however, found that the proposed amendment to the Public Finance Management Act 2012 was not included in the newspaper advertisement of 7th May 2018 or in the impugned act, yet the act ended up amending Section 24 of the act by introducing Section 2A. It is our finding, and we so hold, that the amendment to Section 24 of the Public Finance Management Act 2012 was effected without seeking the views of the public thereon, and consequently failed to meet the edict of the Constitution requiring Parliament to involve the public in its legislative business. It is our finding, therefore, and we so hold, that the amendments to Section 24 of the Public Finance Management Act, by introducing Section 2A therein, made by Statute Law Miscellaneous Amendments Act No. 18 of 2018, is unconstitutional, null, and void. The fourth issue was whether the impugned act was enacted in violation of the principle of public participation. This is as opposed to in relation to the omnibus bill. And again, we have found, as in the previous decision, that there was sufficient public participation, and we therefore find no basis to impugn the actions of the legislature in this case. The final order in this regard, I think, we related to whether the impugned bill required approval by the Senate, and we found that it is incumbent on a party who claims that the Senate was not involved in the enactment of a particular law to show that the impugned law concerns county governments. We find that the petitioners have failed to discharge this duty in this matter, and we've noted that the fact that some of the statutes amended by the impugned act had previously been amended or passed with the participation of the Senate does not necessarily mean that those laws concern county governments. The fifth issue was whether the impugned amendments violate or threaten violation of rights guaranteed under the Constitution. We have found that while the petitioners have listed a number of statutory provisions which were amended by the impugned act and which they allege violate or threaten to violate constitutional rights, they have not demonstrated as required of them that they have in what manner these provisions violate rights, nor have they demonstrated which rights are threatened with violation. Accordingly, they have failed to discharge the burden imposed on them in this regard. The next issue was whether the impugned amendments, and specifically the process of names established under Section 9A of the Registration of Persons Act, threatened the right to privacy. And in this regard, our findings is similar to what we have found with regard to the previous decision in relation to the right to privacy, but insofar as GPS and DNA collection is concerned, we have found that the collection of DNA and GPS coordinates is unconstitutional. I think the last issue is whether the procedure for appointment of the chairperson or members of the Board of Communication Authority of Kenya under Section 6 of the Kenyan Commission of Communication Act 1998, as amended by the impugned act, violates the Constitution, particularly Article 34(2)(a) of the Constitution. We have considered the amendments to Section 6 of the Kenya Information and Communication Act against the provisions of Article 34(5) of the Constitution. We have taken the view that a media regulator that is controlled by government, which we find would be the case should the appointment of the Board of the Communications Authority be left to the process set out in Section C6 of KECA as amended by the impugned act, would pose a serious threat of violation of the right to freedom of expression of the media guaranteed under Article 34, Article 5, and would be in conflict with Article 34(5). It is our finding, therefore, and we so hold, that Section 6 of the Kenya Information and Communication Act, as amended by Statute Law Miscellaneous Amendment Act number 18 of 2018, is unconstitutional, null and void. In light of the above findings, we have come to the conclusion that the petitioners have established, albeit to a limited degree, that there was impropriety in the procedure of amendment to the Public Finance Amendment, in the procedure of amendment of the impugned statutes in the impugned act, insofar as related to the Public Finance Management Act. We have also established that the amendments to Section 6 of the Kenya Information and Communication Act by the same act violate or threaten to violate Article 34(5). We have also considered and agreed with the petitioners that collection of DNA and GPS coordinates, as mandated by Section 5 of the Registration of Persons Act, violates or threatens to violate Article 31 of the Constitution. We have also considered the question of costs on which the parties have submitted at length. The final orders that we find the petitioners are entitled to and which we hereby grant are as follows. In terms of declarations, we declare that Section 6 of the Kenya Information and Communication Act 1998, as amended by Statute Law Miscellaneous Amendment Act number 18 of 2018, is unconstitutional, null and void. We also declare that the amendment to Section 24 of the Public Finance Management Act, introducing Section 2A therein by Statute Law Miscellaneous Amendment Act number 18 of 2018, is unconstitutional, null and void. We also declare that the collection of DNA and GPS coordinates for purposes of identification is intrusive and unnecessary, and to the extent that it is not authorized and specifically anchored in empowering legislation, it is unconstitutional and a violation of Article 31 of the Constitution. Consequently, insofar as Section 51G and 51HA of the Registration of Persons Act requires the collection of DNA positioning and coordinates, the said subsections are in conflict with Article 31 and to that extent are unconstitutional, null and void. And we have also in this case also issued an order indicating that the respondents are at liberty to proceed with the implementation of NIMS, but conditional on the enactment of an appropriate and comprehensive regulatory framework on the implementation of NIMS that is compliant with the applicable constitutional requirements identified in this judgment, and that such regulatory framework is first enacted before